Okay, I think the chair is all right. Yeah, that's it. For the other presenters, you can stay here.
Hello.
Good afternoon, sir. We can hear you. Can you hear us? Good afternoon, sir. Can you hear us?
Yes, I can hear you very well. I can hear you very well.
Okay, sir, you can proceed.
All right. Good afternoon, everyone. My name is Oluwaseun Afolabi, and I believe we are in the session 10A about human rights and justice. I don't know if Eniola Idi Luade Oluwatundumi and Timileyin Kayode Ajiboye, are they around? They are not around. Okay. It's Charles Epo. Is there around Charles Epo?
Is Charles Epo? Charles Epo is not around. I think Emmanuel will start. Emmanuel is the next person in line. I think you should start. Charles Epo is not in the group.
Can you hear us? I think it's close.
Stop now. Oh, yeah. So, Emmanuel, if you would like to start, the panel is supposed to have 12 minutes for presentation.
Yeah, around. Okay. Fine.
Hello. I think Emmanuel is ready to start the section. I think Emmanuel is.
Can you hear me?
Yeah, we can hear you.
Can you hear me?
Yes. Can you hear us?
Okay.
Can hear you.
Can you hear me now?
Yes, we can hear you.
All right. I want to ask if Eniola Ibiluade and Timileyin Kayode are they around?
No, they're not.
Okay.
So I'm Emmanuel.
Is
Charles Ekpo? You said?
No, it's not. No, Charles Ekpo is not here. Emmanuel is here.
I'm
Please
here.
let Emmanuel start, and then when the others come, they will start. Please.
You can join.
Yes.
All right. If Emmanuel is here, then Emmanuel can start. Emmanuel is presenting a paper on strategizing law, human rights, and governance in Cuban Nigeria, 1987 to 1997. Emmanuel, you have the floor now.
Thank you, Mr. Chair.
Thank you to the audience for being here and for participating in this panel. The only slight change to my topic is that it primarily focuses on Lagos, but I use that as a microcosm to talk about larger phenomena across urban Nigeria during this time period. On March 4, 1996, human rights activists from the Civil Liberties Organization, the CLO, took to the streets of Lagos, Nigeria, to protest the arbitrary penal system of General Sani Abacha's military regime. Characterized by detention and harsh prison conditions and summary executions, they believed this system violated fundamental human rights. Utilizing their chants and placards, they castigated the regime and held it responsible for what they perceived to be a deplorable human rights situation in the city. The activists accused the Abacha regime of being the most repressive ever recorded in Nigeria's history, and saw open confrontation as, quote, perhaps the only way of engaging a government that had no sense of respect for human rights, end quote. The peaceful protest soon turned heated when state security agents from the Nigeria Police Force clashed with the demonstrators, injuring some and arresting others as they dispersed the crowd. Now, such occurrence was relatively common, and it represented the typically hostile relationship between human rights non-governmental organizations, or NGOs, and the government. Yet, a few months later, the same organization collaborated with the state on this human rights issue of penal reform. This instance echoes a complexity in human rights practice in Lagos under military dictatorship. Explaining this problem raises the question, how did human rights practice develop in Lagos during the 1980s and 1990s? This paper argues that the rise of a human rights movement, beginning with the CLO in 1987, transformed such practices in the city by introducing institutional paradigms of confrontation and collaboration. For the movement and the military government, these paradigms were standards of engaging human rights matters based on strategic interests. The strategies adopted by this movement and the responses by the state thus aggregated into two paradigms of handling such matters. One where they clashed with each other, and others where they found common ground. A salient question that does come to mind is, why do these institutional actors mostly confront, but sometimes collaborate in their human rights practices? Concerning that of confrontation, the CLO saw the need to regulate the powers of the state in addressing what they understood to be a terrible human rights condition. Conversely, the state sought to contain dissidents who it perceived as challenging its sovereignty and who aimed to upend the existing power structure in the country. Now, on the rationale behind collaborating, the CLO occasionally considered it strategic, pragmatic, and even expedient to partner with the state on specific human rights issues that were quote unquote politically less sensitive, such as penal reform, as opposed to issues of democratic governance. Now, it should be noted that collaboration in the context of this study does not connote cooperating treacherously with the enemy. This paper demonstrates that the term is imbued with layers of meaning that are fluid and open to multiple interpretations based on historical context. Now, as the first extensive history of such practices in Lagos during the late 20th century, this study is broadly significant in many respects. First, it provides insights into how human rights organizations function within authoritarian political settings, which is useful for understanding similar developments across the continent and in the global south more broadly. Second, the argument on institutional paradigms provides an analytical framework to better understand human practices and state-civil society relations in Lagos and possibly across Nigeria and post-colonial Africa. Finally, by focusing on the city of Lagos, this study portrays how the urban space became a site of contestation over state power. Now, this case study analysis contributes to knowledge on the relationship between urbanism and claims making. Now, I'll speak briefly about this confrontational paradigm. In advancing its agenda of effecting social change on matters of human rights, CLO activists adopted adversarial strategies. They believed the military government was the single most significant threat to the protection and promotion of such rights in Nigeria. As such, they sought to regulate state power and by extension, improve the human rights condition in the country. Now, mass protest was one major approach that they adopted in Lagos. The CLO was known for mobilizing individuals at the grassroots level, an approach that it usually implemented through Lagos-based coalitions, such as the Campaign for Democracy, the CD. Now, in June 1993, following General Babangida's annulment of the elections that held a month before, the CD organized mass protests and printed out hundreds of leaflets urging Nigerians to stand against the military dictatorship and the, quote, subversion of the popular will and the violations of fundamental human rights, end quote. This urge for confrontation was because many, including voters and foreign observers, considered the elections to be free and fair, and its annulment a desperate attempt by the regime to maintain power. Now, on the 3rd of the following month, the CD distributed such campaign leaflets at a football game in Surulere, Lagos, in their efforts to mobilize the spectators. This campaign culminated in a 5-day protest with over 80,000 persons across several days reportedly in attendance. Now, there are other aspects that really go deeper into the confrontational dynamic of this story, and I'm happy to speak about that in more detail during the Q&A. These instances portray how mass protest was a strategy that the movement employed in making claims within the urban space of Lagos. It was a risky, uncertain, but recurrent method through which activists engaged the state within this paradigm of confrontation. The military regimes also adopted their own adversarial strategies in responding to such issues. It viewed these human rights activists and advocates as rabble-rousers who sought to challenge their authority and upend the existing power structure. As such, the state saw the need to, quote unquote, curtail these human rights dissidents by any means necessary. One of such strategies was to intimidate human rights activists in the movement. In early 1996, for example, state operatives illegally seized the passports of 3 officials of the CLO, including Olisa Abakuba, Ayo Obe, and Joseph Ote, who were co-founder, president, and head of its legal directorate, respectively. Now, the CLO considered these to be acts of aggression, which, quote unquote, grossly undermined their rights to free movement as guaranteed by the Universal Declaration of Human Rights and all other international legal instruments to which Nigeria officially subscribed. This instance of state-sanctioned repression was one of many that the activists faced during the 1990s. Now, I'll move briefly to the paradigm of collaboration, where they found common ground, and then I will conclude the presentation. Now, since the government and the CLO typically confronted each other on human rights matters, how does one then make sense of why these actors also collaborated? Popular narratives held that such collaborations that occurred between the state and civil society during a period of severe military dictatorship in Nigeria were due to coercion by the government. While there was some truth to this, especially considering the cases that I just referenced, this paper nonetheless goes beyond that narrative. Now, it shows how, mostly in the 1990s, a paradigm of confrontation also existed, within which NGOs and the regime cooperated due to evolving strategic interests. In instances when it was pragmatic, these actors utilized, quote, friendly approaches, end quote, in engaging human rights issues that they deemed politically less sensitive, such as penal reform. Now, this interpretation underscores the need to reference agency and historical context to better understand the transformations in human rights practices that occurred during this period. Now, one of the ways through which these two actors found common ground was by initiating joint projects between state and state-sponsored entities. So most of these projects were through the Ministry of Justice and through the newly formed National Human Rights Commission in 1995, where they sought to reform the penal system by improving prison conditions and abolishing the death penalty. Now, some of the ways through which my research has focused on areas where these actors collaborated are by looking at materials like correspondence, looking at official government gazettes, also looking at legal and extra-legal documents like military decrees and what have you. So these are some of the ways that I engage this paradigm of collaboration. One of the examples through which they sought to improve prison conditions was at the Kirikiri Maximum Security Prison in Lagos, where they sought to address the plight or improve the plight of prisoners in that prison. Another aspect too that touches on that was the establishment of the NHRC, the Human Rights Commission. And that's another angle I could talk more about during the Q&A. Now, to conclude, with the advent of the CLO in 1987, Metropolitan Lagos witnessed the rise of an NGO movement which transformed human rights practices in the city. This movement emerged within a political setting that was authoritarian, which offers broader lessons about how activists operate within such repressive regimes. The story told here is one of how these activists navigated the constraints of military rule as the state sought to perpetuate its power. It also analyzed how they occasionally reached some consensus with government officials based on strategic interests. While both parties typically adopted adversarial strategies in engaging human rights issues, they also explored cooperative ones. I have argued that these strategies aggregated into institutional paradigms of confrontation and collaboration, between which this movement and the government opposed but sometimes cooperated with each other. Moreover, the CLO case study nuances our understanding of collaboration. It showed that depending on the historical context, the concept does not invariably signify betrayal to a common cause. This underscores the need to rethink and to think more critically about collaboration as a historical category of analysis. Nevertheless, for these human rights activists, the late 20th century was an era of surviving dictatorship, regulating state power, and finding common ground. Thank you for listening.
All right, thank you, Emmanuel Sanyode, where you talk about the paradigm of confrontation and the paradigm of collaboration between the CSO and the government, in which they are being coerced by the government, but at the same time, of course, they initiate joint projects and, of course, improving the plight of prisoners and also about the NHS. Thank you very much. Is Doyinsola Ibikunle, is he on seat?
Yes, yes.
He'll be presenting the language of the law, coloniality, and the administration of justice in Nigeria. You have the floor now.
Thank you. Good day, everyone. I'm presenting the paper on the language of the law, coloniality, and the administration of justice in Nigeria. The paper examines the underlying influences and motivations that shape the language of the law, both historically and in contemporary times. In doing so, the paper hopes to illuminate the relationship between coloniality, language, and the administration of justice in Nigeria. We examine language as English language and also in the coinage of words. So what are the problems observed that necessitated this research? We see that it is essential to recognize that law is inherently rooted in cultural and historical context. And so to appreciate the impact of colonialism on the development and understanding of the law. Now we try to analyze the legacy that colonialism left on the legal system of Nigeria. We say that the legal framework and the language of the law perpetuates a disconnect from the indigenous cultural context. Now, this disconnect usually reinforces power imbalances, suppresses indigenous legal practices within the Nigerian legal system. And I give you an example, which is not necessarily about the written laws. During the last elections, I was an observer, and the community where I went to observe was made up of mostly illiterate people. Now, as they started to gather to get accredited, the party agents came to say that when people want to vote, there will be a party agent who stays with them to guide them in the process of voting. And the INEC officials were refusing, the police were involved, and all of that. And then I also contributed and said, it makes no sense that a party agent will be there when you are voting. And then some members of the community came to me and said that, Madam, by evening when we are counting these votes, you would almost be crying because all the papers would have gone to waste. And that is our custom. It is our tradition in this community. We are organized, we are orderly. Each of us knows the party that the other belongs to. And then in fact, there will be no, what do we call that? There will be no malpractices, because it's almost like an open ballot system. Now, as you approach the agent for whose party you want to vote, because in fact, the indigenous of that community cannot read PDP or APC on a ballot paper. Neither can they recognize a broom or an umbrella. And as they were making that analogy, I was in disbelief. Just as that was going on, a woman took the papers and went to dump them in the boxes without thumbprinting at all, and said that she had voted. So this calls for a rethink. How do we bring a language and some values that are not indigenous and expect that people's rights are protected? If we do not consider these people, we would have unknowingly disenfranchised them from voting, and the ballot papers would have gone to waste, just as I was advised in that community. Now, I will talk about how Nigerian laws are symbols of colonial heritage. And then, first of all, I'll give a historical context to colonial legacies in Nigeria. We'll all agree that the Nigerian legal system, as we have it today, mostly emerged from the colonial history, which has influenced the social, political, and legal structures. The law as we have it today was comprises mainly of the received English laws, which come from common law doctrines of equity and some statutes of general application. And so because of this, you can hardly separate the laws that we have in Nigeria now from the colonial legacy. Also, another evident way in which Nigerian laws symbolize colonial heritage is through the use of language, concepts, terminologies, and all of that. So consequently, you see that the language of Nigerian law predominantly reflects the cultural and linguistic imprint of the colonial era, perpetuating a disconnect between the law and the indigenous cultural context. And I'm coming to give examples of that very shortly. Also, you see importations and adaptations of legal concepts that have no roots in the culture and indigenous practices of the people in Nigeria, forming the laws that Nigerians have to obey against the natural order of the cultures of the people of Nigeria. So we have this cultural clashes and impositions. Now, recognizing and critically examining some symbolic dimensions of the Nigerian legal system rooted in colonial heritage, I'll give some examples here. And the first one that I'll be looking at is the adoption of legal concepts and superimposition of British norms and values. The first one that I would like to talk about is the adversarial versus the inquisitorial legal system that we have here. In Nigeria, we practice the adversarial legal system as imposed on us by the colonialists. And in fact, what the indigenous legal system of most of Nigeria's people is the inquisitorial system. And that's why many times you will go to court and see when they arraign a person, the first thing they want to know is, are you guilty or not guilty? Then you see the person struggling to say, I am guilty, but with explanation. And then the court officials say, no, you either say you are guilty or you are not guilty. The man again tries to say, no, I don't just want to say I'm guilty. I want to explain to you. What that man is trying to say is, why not inquire? Instead of trying to make me reach a conclusion before you have investigated or before you have seen evidence. Now, the next one that I want to look at is some concepts of law. For example, torts, what we know as torts, which are civil wrongs. And I like to focus on invasion of privacy. The concept of invasion of privacy as it is strange. As it is in the laws, it's strange to the indigenous Nigerian people. So you would naturally find your neighbors coming to knock on your door. You find their children coming to eat in your house. Culturally, indigenously, there were no such boundaries as saying that, in fact, the cultural systems had a way of, expressing their boundaries without necessarily having written laws to that. And that's why you will hear a Yoruba proverb which says, that means it is not until you write to me or you put it in laws about invasion of privacy, we already know where the boundaries are. The next one that I will be looking at, because of this, there have been recent reforms and changes of some terminologies and language in the construction of law, because we all know that language engenders mental conditioning. So, for example, recently in the new Administration of Criminal Justice Act, we now no longer refer to people as accused persons. Instead, you refer to them as defendants, so that as the person is standing there, you do not begin to think that he is an accused person. Instead, your mind shifts to allowing this person defend himself. And because of that change in language, you see a significant change in the process that leads to justice. You also see how the Nigerian Prison Services has now been rebranded to be the Nigerian Correctional Center. Thank you. The next one, we have the language barrier, and I'll focus on this a bit. The language that we use in courts and to write our laws is the English language. And we know that the majority of Nigerians do not even understand the English language. Yet we say that ignorance of the law is not an excuse. When we have put the law in a language that people do not understand, do not even have the facilities to be educated in order to understand the language. And so because of that, what you find is most of the litigants do not understand the language of the court or of the law, but yet they are expected to get justice using that language. And then what you see is there is the process of interpretation. So you see a judge, my lord, with the heaviest tribal marks you have seen and the thickest or your accent, says that the matter cannot continue today because there is no interpreter. And then on the day that the interpreter comes, the interpreter interprets wrongly, because we all know that context gets lost in translation. The interpreter interprets wrongly, and then my lord says, no, that is not what he said. So if you know what he said, why are we wasting time? Why do we have to keep adjourning, and in the process delaying justice, clogging, the will of the system? We have matters in court for so long just because of this language and interpretation problem, which engenders delays. Another one is the way that lawyers dress to courts. As mundane as it seems, it is one of the things which stalls justice. Many times you will see in this Lagos hot weather, you're fully dressed in a suit. In fact, three-piece suit, you have your collar, everything, you have your bib and all that, you have a wig covering your head and all of that. There's no fan, there's no electricity, and then you are fully robed again. You are very uncomfortable. And once it's 12 o'clock, my lord says, gentlemen, we have to call it a day because the court is uncomfortable. Because of that, we lose man hours that should be valuable in addressing justice. If we do away with this, perhaps we'll get more hours to dispense justice. The next one that I want to talk about is the concept of adultery. You would hear that adultery is a crime in Nigeria, but the average Nigerian is a customary law person who believes in, at least the men, who believe in polygamy. So you will find someone who has gone to marry under the act and then is marrying a second wife. And then the wife comes to court and says, my lord, I would like to the marriage to be dissolved because my husband has now gone to marry another person. Nobody's prosecuting that man who has broken the law. Instead, you hear the judge say to the woman, why? Because your husband married another wife. You are the first wife, you are the madam of the house. It's not a big deal. Even I have 3 wives. My Lord says that. And so, there's this clash. Why is it in our laws? I mean, if you want to just go with the customary laws, then you should as well go with that. We also have the recent case of Ayo Shogunro, which some of us may be familiar with, about in the north, in Abuja actually, where Ayo Shogunro was arrested because a married woman had gone to visit him in his hotel room. There's no proof, there's no evidence that there was any adultery, but then he has been arrested. Now that raises the question whether the penal code, which mostly comes from Islamic law, is superior to the Constitution of Nigeria, which says that everybody has personal liberty and freedom of movement. And I also question, where is the discretion of this married woman or a liability in the ongoing conversation? Thank you very much. Oh, sorry. My recommendations. So we recommend that legal terminology be clear to prevent a barrier to understanding, especially for those outside the legal profession, in order to enhance clarity, eliminate ambiguity, and promote better access to justice for all Nigerians. The complexity and opaqueness of legal language can create barriers to justice, particularly for marginalized communities. Thus, the language of the law should be simplified and localized, making it more accessible to such individuals. So laws can definitely be interpreted or translated into languages that people can understand, instead of just having laws in English language, which many Nigerians actually do not understand. In addition to linguistic changes, we suggest the introduction of procedural changes. Procedural reforms can greatly impact the administration of justice, influencing the efficiency, fairness, and effectiveness of legal processes. We further recommend the incorporation of technological advancements within the administration of justice system relating to electronic filing, digital signatures, or online dispute resolution mechanisms and court hearings for efficiency, accessibility, and equal access to justice, because justice delayed is justice denied. Thank you for listening.
Thank you very much, Doyisola Ibukunle. I found your presentation very interesting. I remember that there was a time a particular lawyer dressed in indigenous way to the High Court, maybe in Abuja or in Lagos then, and they are trying to deprive the man to enter the courtroom, and was challenging them that he can dress that way, he can dress in an indigenous way. There's nothing wrong with that. And of course, I think there is a need to actually indigenize the law so that there will be effective justice. But I don't know how we want to do that, because the Nigerian law is crafted from the British law, and I don't know how I want to do away with that without doing injustice, so to say, to the Nigerian law, all because we want to make sure that the indigenous culture is adapted into it. But it's a food for thought and a further discussion. Thank you very much. I don't know, I think George Osei is online with us.
Hi.
Am I right?
Yes, I am.
Yes. Okay. George Osei will be presenting Human Rights in Everyone's Rights, Native Rights and Ghana's Independence Struggle, 1946 to 1966. You have the floor.
Okay. Thank you so much for having me, and good afternoon to my fellow panelists and guests seated. I don't know if there are people. My name is George Osei. I'm third-year doctoral student in Stony Brook University here in New York. And the title of my paper changed slightly, so it's now Human Rights Are Everyone's Rights, Native Rights and Ghana's Independence Struggle, 1946 to 1966. So just before I start, I want to explain that I use native rights here to refer to freedoms and liberties which were drawn from indigenous African systems, as well as from European universal rights ideals, which became important during the Age of Enlightenment and then gained further prominence after World War II with the establishment of the Universal Declaration of Human Rights. So in May 1898, the Gold Coast Aborigines Rights Protection Society, led by its leader, Jacob Wilson Say, embarked on a trip to London in order to advocate for the dismissal of the Lands Bill of 1897 in front of Joseph Chamberlain, the Secretary of State of Britain at that time. It was through their meeting with Joseph Chamberlain that the ARS was able to get support for the termination of the Lands Bill of 1897. This bill, if enacted, would have allowed the colonial government to take over what they termed as waste or public lands in the Gold Coast. The ARS's appeal for the British authorities to recognize the rights and dignity of Gold Coasters signifies an opposition to colonial rule, which was still gaining roots at the time. By calling on the discourse of rights, Jacob Say and his group not only challenged imperialism, but also showed that they had understandings of rights. This paper argues that native rights were already part of the experiences of Gold Coast and more broadly Africans prior to the establishment of the Universal Declaration of Human Rights. And it was these notions or principles of native rights which were called on to challenge European imperialism and were used in the period of Ghana's independence struggle. By focusing on the discourses of native rights, this study presents a new interpretation of Ghana's independence struggle. It shows that native conceptions of human rights, like that of political representation and then the right to land, were very important, and as such, they need to be studied as part of the narratives of anti-colonial resistance and should be considered as major contributors to the political changes of the period. In this study, I asked three main questions, and these are: how were native conceptions of rights formed? How were these rights politicized in the period of nationalist agitations? And how were they used in the early post-independence period? And to answer these questions, I employ varying sets of sources, which include archival documents in the form of newspapers, colonial government reports, and also in oral histories in the forms of interviews with kin of some people during the, some people who were involved in the independence struggle at the time. There is a wealth of scholarship on human rights in Africa and around the world. And from looking at scholars like Jack Donnelly and Bonnie Bao, they all argue that human rights can have a utilitarian function such that they can be used to express aspirations, suggestions, requests, and also they can be used to legitimize, oppose, and even negotiate. Thus, we see this utilitarian functions of human rights being able to facilitate transformative processes. Recently, other scholars like Abner Sari have also shown that human rights became a tool to challenge the inequality of the global political order, whilst also being used in local political conflicts, something that she has termed as the malleable human rights rhetoric. The common theme here, like I said, is that human rights can be utilized as a tool to bring about radical change. And so by focusing on human rights, on the use of human rights by groups like market traders, youth activists, my study not only eliminates these utilitarian functions, but it also moves away from these big men narratives in terms of rights talk. And so just to go into a bit more detail here, I want us to look at how native right conceptions of rights were formed. And I use the Akan group of present-day Ghana as this microcosm to bring these out. And so we see here that the Akan conception of, prior to this enactment of human rights principles in 1948, that's the UDHR, the Akan notion of human rights or claims to rights was more akin to this abstract notion of human dignity, which supposes that all humans have an intrinsic worth. And so here I quote from this philosopher, Kwesi Redu, who notes that the Akan conception of a person has both descriptive and normative aspects that are directly relevant not only to the idea that there are human rights, but also the question of what those rights are. In this conception, a person is as a result of the union of three elements: the life principle, the blood principle, the personality, and the personality principle. So by virtue of possessing on Okada's the life principle, a divine element, every person has this intrinsic value and is the same in each, and he does not owe to any earthly circumstances. So here, the Akan worldview of a person's intrinsic worth assumes that all persons are of God, and such that there is this general respect for people's rights, even though they were not codified or had this contemporary legal backing like the various human rights conventions do. And so in pre-colonial Akan society, political rights were exhibited through the family or lineage heads, who was part of the king or chiefs of the area's council of elders. And so even in the midst of colonial rule, we see that Gold Coasters found new ways of political representation, and this became geared towards national independence. So at this instance, when nationalist agitations became more widespread, Gold Coasters championed the need for political representation. And there's this example in one of the newspapers, the Asante Sentinel newspapers, published in 1954, where a prominent market trader, went around campaigning to all heads of other market women to canvass for votes to support the then leader Kwame Nkrumah's message of an independence Ghana. So here I use this to show that the CPP, which is Kwame Nkrumah's party, had become this avenue through which ordinary people like Madam Freema could seek political representation. And even in Nkrumah's own biography, and here I quote, he says that much of the successes of the Convention People's Party, that's his party, has been due to the efforts of women members. From the very beginning, women have been chief field organizers. They have traveled through innumerable towns and villages in the role of propaganda secretaries and have been responsible for the most part in bringing about the solidarity and cohesion. So fervent were these women, in fact, that while I was in prison and the party organization was at its most critical period, I learned that at a rally in Kumasi, a woman party member who adopted the name of Ama Nkrumah got up on the platform and ended a fiery speech by getting hold of a blade and slashing her face. Then smearing the blood all over her body, she challenged the men present to do likewise in order to show that no sacrifice was too great in their united struggle for freedom and independence, end quote. So I explain this as this smearing of blood, which signifies a deep connection with family, because we talked about this Akan notion of family of a person, which had this blood ties to show that Ama needed or demanded this political representation. And as such, this notion of this political representation, this colonial notion of how leaders were represented had now transformed as part of seeking representation for self-rule. And another way we can look at this too is the issue of issue of land rights. And so, since European colonists dominate all manner of resources in their colonies through control and use of the control and use of land became highly contested, right? And as such, chief among these contestations were the different meanings attached to land use and land ownership. A 1933 report on the issue of land rights presents a vivid example of these different conceptions of land. This report to the Colonial Secretary of Gold Coast, which was titled Land Tenure in the Protectorate and the Development under the Land and Native Rights Ordinance, notes that the land tenure generally in the, and here I quote, the land tenure generally in the Protectorate is or was in 1931, when the ordinance was enacted, a purely native system of land tenure in which the native conception of land is God-given, like air and water. Every single individual is entitled to share. But land is not simply the property of the living. It belongs also to the ancestors and future generations. Such is basically the situation in the Northern Territories today. And in that state of affairs, the Land and Native Rights Ordinance was enacted. And it goes on to say that throughout the protectorate, the control of land is in the hands of one or other of the land priests, who are known as the chiefs or the Tendana. And these priests are in absolute control of land under their jurisdiction, both as in regards to tenure and practical rules of agriculture, and can eject an occupier who is unsuitable or who farms in an unhusbandlike manner. So in essence, land was held in trust by the king or chief on behalf of the community, who could use it as needed. And so while colonial authorities view land in terms of commodities to be plotted and sold, Gold Coasters regarded land in usufruct terms, right? That's the use of land rather than this complete ownership. So with no absolute owner of the land, its use kept changing while still maintaining its significance and value for the people. But here we see that when Europeans came, they plotted and sold these lands. And so in an interview with one Mr. Akonto, who was a son of a former trader in Kumasi Market, he recalls that his father telling him that during this period of nationalist agitations, you could hear chants from people, these local chants saying that which literally means that the literal translation be that we would not sit down for them to take all our land. And so in calling for an end to imperialism, Coasters drew on the language of land rights anchored in their indigenous value systems of land to seek for self-rule. And so in the period after independence, the political structure of the Gold Coast changed. Power was now in the hands of the nationalist leaders like Nkrumah, who became Ghana's first prime minister and then president in 1960. But this period, which is termed as the Nkrumahist era, saw development of state control over numerous institutions and organizations, and ultimately led to Ghana becoming a one-party state. And just like colonial times, Ghanaians called on Rice claim to navigate and challenge Nkrumah's rule. In 1959, the Ashanti Pioneer newspaper report titled Richardson Telegraphs Nkrumah explains the use explains how Ghanaians used their rights. In this report, Richardson, who was then secretary of the United Party, knows that we fought for independence to be able to live as free men, governed by principles of the UDHR, as well as Ghana's own coat of arms motto, that's freedom and justice. End quote. Essentially, the language of rights, which became more profound after the UDHR, together with Ghanaians' own notions of rights claim, became an anti-authoritarian weapon. Ghanaians deployed rights talk in their own ways to oppose Nkrumah's government. And in 1966, when the government was eventually overthrown, leaders of the National Liberation Council, the architects of the coup, encouraged Ghanaians and the world at large that Ghana's path was set towards the realization of true human rights. So I'd like to conclude by noting that this paper has presented an account of the use of native rights in Ghana's independence struggle from the late colonial period to the early post-colonial period. The argument is that while the Universal Declaration of Human Rights signaled the beginning of enjoyment of exercise of contemporary liberties and freedoms, such freedoms were already part of the experience of Gold Coasters prior to its enactment. And in fact, it was claims like those of political representation and property rights or land rights, which were crucial elements in the fight for independence. Moreover, this paper has shown the amenable and utilitarian nature of rights discourse, in that rights have been used to dominate and resist domination, defend and criticize, legitimize and seek delegitimization. This is a history where politicians, journalists, and citizens marshaled rights talk, deploying it when necessary for use in local political oppression and simultaneously confronting the inequity and imbalance of power associated with colonialism. Thank you so much for your time.
Thank you, George Osei, Osai for the brilliant presentation about human rights is everyone's right. Well, I believe truly that human rights is everyone's right because I believe that human rights is your right, is divine, is innate, is something that is bestowed on you, in which I believe nobody can just take that right from you because nobody actually gives you that right except from the divine. So, and of course, from the issue of freedom and liberty, the native rights was enacted. So it's a beautiful presentation, and I appreciate you for that. I don't know if Eniola Ibi is still around.
Is there any
And Timilen Kayode, are they in the room?
No, they're not.
Okay, no problem. Well, we are in the section of questions and answer. I don't know if anybody have questions in the room. Anyone that has questions for the three presenters? Anyone in the room?
Yeah, so,
There's no question on Okay, you have the floor, sir. You have the floor.
Oh, yeah, thank you.
Sir.
So, yeah, so I have some comments for Emmanuel and some questions. The first is, I wonder if the personal experiences of the CLO members formed their pragmatic use of seeking solidarity. For example, did they spend some time in the prisons so that they were able to see the kind of conditions that the prison systems were? So that the things that they could not achieve, for example, for democratic participation and whatnot, they then had to resort to some things that they had very personal experiences about. So if the end of democratic consolidation could not be achieved, they could then reach out to personal experiences that perhaps they spent some time in Kirikiri, for example, like a lot of them were used to, like the arrest. I wonder if if you consider that the personal experiences of these members could have informed the kind of strategies that they now deploy. I wonder if that's a consideration for you. For Doyisola and George, I was wondering if you think that there are actually linkages between the Land Use Act in the old Gold Coast and the Land Use Act in colonial Lagos, and how, for example, they're now the land tenure system as we have them now. So the fact that the government owns land in trust and that you cannot necessarily own property, like long-term hold on property, you have to get government consent. I wonder if that's not a continuation of that colonial legacy of how the land is supposed to be held, whether it's in trust or in perpetuity or whatnot. I wonder if there are connections with the Ghanaian land tenure system, which I am not quite familiar with, and the Nigerian land tenure system that I think I'm a little bit familiar with. So those are the questions that I have for the brilliant presentation. Thank you.
so anything else?
All right. Okay.
Thank you for the brilliant presentation. So I'll start with Emmanuel. So I have a question because earlier when we were talking about, you were talking about your paper, you said a lot of something about development of human rights practice in Lagos, and something really struck me when you talked about transformation of the prisons. The contributions and transformation of prisons. Can you please give a little bit explanation in aspect of how the prisons was transformed in the aspect of politicization. That's where the prisons were politicized, because that's the military rule. Definitely, it has an aspect politicized, and I have a bit of problem with one of your recommendations. You spoke about, if I should just put in a word, legal inclusiveness. Legal inclusiveness, and looking at the situation of languages of law in Nigeria and trying comparing to the situation in South Africa. I think South Africa had a little of changes when it comes to interpreting their constitutions and laws into local languages. I read a part of South Africa constitution where they define some important situations in local languages. But looking at Nigeria, Nigeria is a mega ethnic country, right? How do you foresee interpreting that? I'm very sure you're Yoruba, right? Yoruba, they have several languages, but you know, that there are some things in academic that we don't see that it's going to be practice. Yeah, it can't come to practice. You understand? So 1960 Constitution had its basis, it has its flaws. They reviewed the Constitution to the 1999 Constitution. 1999 Constitution so has its own flaws. But presently, I don't think legal inclusiveness by translating all our laws into indigenous languages is foreseeable. So I think we should look for other strategies of ways in which we can include these indigenous people, and also looking at the aspect of legal imperialism, because Nigeria is basically, we have three major laws, right? You kind of spoke a bit about the Islamic aspect, Sharia, because looking at the Sharia and that's the penal code and criminal code, there's divided Nigeria into two. So which aspect of inclusiveness are we trying to look at? Do you want us to merge the penal code and criminal code together to make us one? So I just think we need to be very careful when we talk about legal inclusiveness and Nigeria's future, because this is talking about, basically, to me, I interpreted it like, okay, we are still going to divide in Nigeria if we go about this legal inclusiveness. So I think we need a proper rethink on how to move forward when we talk about languages of law. Thank you.
Thank you. Any other question for the presenters? Any other question? The presenters? Well, if
any
other question?
Oh, I don't think you have any other question.
Okay, I will allow the presenters to answer the question. Doinsola Ibikunle.
Yes, yes. All right, so
you have the floor.
Okay. The first question is on the similarities between the Land Use Act or land tenure system in Ghana and in Nigeria. So while I may not be the right person to speak about the land tenure system in Ghana, I can speak about that of Nigeria. Now, some days ago, I was in a session where one of the panelists actually said that, okay, first, before I say that, we know that the land tenure system, for example, in the South is not an indigenous thing. People had their land, you settled on your land, and then you owned the land. Nobody else land, you own land you trust for your descendants. I mean, so with the Land Use Act, what I found out in that session that I went, the person actually said that the Land Use Act, as we have it now, has the same words and coinage with some law from 1912 in northern Nigeria, which was actually a law by the British. So I know that the Land Use Act and the land tenure system as we have it now is actually something that came from coloniality. One of the things we do majorly in Nigeria is to just adapt laws, just change the name, change the words, and then not necessarily look at the spirit of law. So George, I'm sure, can speak about the land tenure system in Ghana. Then the second question about legal inclusiveness. The truth is, how I look at it, you cannot do everything in one day, but you can do what you can. So for example, if I mean, some of us can translate, I understand the cultural diversity, I understand that languages are as many as people, but that you have it in one language doesn't mean that that you have it translated to some languages will not affect the legal rights of those languages into which they have not been translated, and it will also not diminish the rights of the people into whose languages they have not been translated. At best, we can get better results in some parts of the country. I also would like to think that perhaps in most of the communities or the places where these diverse languages are represented, and apart from that, they will have so for example, the people of Ibadan or York all understand Yoruba, so we could adopt Yoruba for all of those. However, if we are able to translate into Ibadan, Ekiti, Ijebu, it will not diminish the rights of an Igbo person who doesn't yet have a translation. I don't know if this is out, but I know that the religious books are translated into so many languages, and up to today, they haven't yet captured all the languages that exist. You know, many of those communities too, we have higher institutions of learning and some research institutes that perhaps could help with this. But of course, it will be an ongoing process. It will not be achieved in one day. And at best, I think it's just a suggestion. Have I answered your question? Yes. Okay. Very good.
Okay. All right, I think there's a question for George Hussain.
Yes, yes, I'm here. The land system now is the president, holds the land in trust for the people. So that means the power has now been taken away from these traditional leaders or traditional rulers. And that's how it works.
So in essence,
all right, thank you very much. I don't know if there's any.
I'm sorry, can you repeat that?
I think in essence, it's almost the same as we have in Nigeria, except that in Nigeria, it's the governors that own land interest.
Yes, I guess so, because the Constitution, that's what stipulates, gives the president that power. And even though it takes this power away from the traditional leaders, it also states that, they are not higher than the Constitution. And so the president's power is higher than their power.
Thank you.
Okay, all right. Is there any question for Charles Ekpo? Is there any question for him? No?
Charles didn't present. George has a question.
Charles Ekpo. Is there any question for him? Oh, sorry. Emmanuel Osanyede. Sorry, Emmanuel Osanyede. Is there any question for him?
There were two questions earlier.
All right.
Is there
any other question?
Yeah. Let me just try to address two questions people in the audience raised. Thank you again. Thank you for. I think maybe you can't hear us. Yeah. But yeah, let me go ahead. Thank you again for your questions. Thank you for your comments, your insights. I'll go first to the first question about how personal experiences, particularly of these activists, could have shaped the strategies they chose to adopt and why they decided to focus on specific issues as opposed to others. And absolutely, their personal experiences did influence not only what issues they sought to debate and to engage, but also the strategies and the approaches they adopted. So for example, on the issue of prison reform, right? Some of these activists themselves have been imprisoned, right? So there's this popular figure, he's a political figure in our current democratic dispensation, Abdul Oro. And way back when, during this era in the 80s and the 90s, he was initially a journalist, also trained as a lawyer, and he started to practice as well, right? So what even spurred him to become an activist when I was having a conversation with him was when he witnessed the execution of 3 accused persons who had been convicted on drug charges. They were executed by firing squad at Kirikiri, and they were executed based on a retrogressive law. So what that means was when they were imprisoned, their crime just carried a prison sentence. And so the Buhari regime came into government and passed a decree that made that same offense now punishable by death. So those were some of the things that he personally witnessed that made him engage this issue, not only legal representation of being imprisoned, but also thinking about their plight while they were incarcerated, right? And he personally later on also witnessed this challenge when he was arbitrarily detained at Alagbon by the DSS, right? And his condition was, something that in his own words even haunts him till today. So those personal experiences really came into play why he decided to focus on specific issues. Another point I'll make in that aspect has to do with even the approaches they took beyond looking at the prisons. So a lot of what they did was to seek legal redress. So they sued the government to court, not just at the domestic courts in Nigeria that were operational at that time, but they took them to places like the African Court of Human and People's Rights. They sued the government to even more international courts like the ICC. They appealed to the High Commissioner of Human Rights at the UN. They even appealed to powerful foreign governments like the US government to levy sanctions against Nigeria during this period. And a lot of that was because of their background and their training. Most of these activists like Abakoba, like Oro, I mentioned Ayo Obe, who was a staunch woman activist at that time, they were all legal practitioners. And so their personal background really informed the approach that they decided to take. Now, on the second question about this dynamic of prison reform being transformed, and also how incarceration was politicized at the time. I think that was also one very key thing to pay attention to in this context. First, it was transformed looking at the logistical dynamic of the prisons. So just thinking about how many people were assigned to a cell, what was the duration in which they were awaiting trial, which has been a problem even till this day, where you have a lot of people in Kirikiri and other maximum prisons that have been awaiting trial for a while. So that's one thing that they tried to address in collaboration with the National Human Rights Commission and the Federal Ministry of Justice to figure out how to reduce the time of those that were awaiting trial, but to also improve the prison conditions as well. Just thinking about providing things as simple as mattresses. When Oro was incarcerated at Alagbon, he told me how for 7 months he slept on the bare ground. And so even some simple sort of logistical improvements were what we were looking at. And one other thing that he used to transform this dynamic of prison reform and thinking about the question of politicization was also the role of the media. I mentioned Oro was a journalist. A lot of my sources are newspaper records, things that you can look into till this day. If you go into like the Guardian or the Punch newspapers and what have you. So this idea of really using public opinion to sway the actions of government was another important thing that he used to address that political dynamic. Thank you.
Thank you very much, all the presenters, Emmanuel, Sanyode, Doinsola, Bikunle, and George Osei. we have a wonderful time with you. And I just want to conclude that, well, from my own angle, I believe human rights should be indigenized and equally justice as well. And I believe nobody's rights should be taken without due process, whether it's the land or even his life. And I believe we can continue this the discussion further, even outside the room. So I appreciate the panelists and all of those that attend the forum. Any other question from the room for the presenters? Any other question?
Yeah, so my contribution is to Emmanuel's presentation. So I wonder if the sort of human rights in principle and human rights in practice dynamics, for example, led into some sort of, so for using the African Human Rights Court as an example, and how they try to use the African, but on the other end, the Nigerian system has not ratified the status of the African, so that because of the kinds of appeals they were making. So appealing to the to public opinion was fine, but they were not right to claiming courts that were out of Nigeria, right? So that if you had such right claims, you wanted to go abroad to claim it, for example, in African court, but the Nigerian court has not ratified it, and so that whether you try as much as possible to appeal to, I guess the point I'm making is about when you realize that some of the claims you are trying to make, and they did try to make judicial claims in Nigerian courts first, and then in international courts. And when those claims are not successful, they have to only resort to the kinds of strategies that you say about public opinion and whatnot. And I'll give an example, even in the case of the affirmative action bill, for example, the 35% affirmative action bill. And there's actually a judgment by the that says that that's actually a justiciable law. It's not a policy thing. It's like because you ratified some of the what's the name? Some protocols that says there should be no discrimination against women and all of that. And in fact, there was a public interest litigation that did take it to court and tried it to the, and there is actually a judgment that says that it is justiciable. But on the other hand, when they were trying to amend the gender bill in the last dispensation, it went nowhere. Right. So I guess the point I'm making is that when you are talking about rights and when you're talking about links to human rights obligations, you need to think about the categories of those links. So when the Nigerian system deliberately says that you do not have this right, or maybe you have them, but it's not justiciable. I mean, if the rights are not justiciable, whether it's debatable whether you have those rights or not. And from my comment to Doyisola, I guess, is about what is the legal system for? Is a question one needs to ask. Is it a question of, is the legal system for dispensing justice, or is the legal system for the state having its way? Right. Is the justice system is the justice system for dispensing justice? Now, if the end of the justice system is to dispense justice, then the system itself has to remove all encumbrances towards that end. In the event that you don't do that and you stick to technicalities, which is what a lot of the Nigerian decisions, judicial decisions are coming to, they'll say, oh, you have no local standard, which is actually one of the strongest points against public litigation, the point of local standard. And the human rights claim is to say that what concerns my brother concerns me as well. And that's literally one of the central arguments of the Universal Declaration of Human Rights, that what concerns any other person concerns me. And I do not necessarily have to have locus. I have locus because I belong to the kindred of humans generally, and that I have such rights that are I'm a sovereign claim on my own right, and I do not necessarily have to obtain it from the state. I mean, that's the central conception of human rights, I guess. So in trying to think about the human rights system and the links to judicial claims and links to human rights obligations, I think that it is important for you especially to think about when you're trying to lay a claim in courts that will not give it to you, you are left with no other choice but to deplore other choices that you have that are available to you. And I think that's a very brilliant contribution that you made with your analysis about human rights and governance and environment.
Thank you very much. Thank you.
All right. I need to bring the session to a close. Thank you, everyone. We can continue the discussion even outside during the lunch break. So thank you all, and God bless you.
Thank you.